Ladies and gentlemen, it is an enormous pleasure to welcome you now to a panel on the future of competition policy, power, politics, and populism. Didn't think I'd be able to get through that without stumbling, but there we are. We have the world's most impossibly distinguished panel of competition policy experts assembled to guide us through what might be the most extraordinary moment in competition policy history for decades. We'll talk about that in a second, but first let's meet the panel. To my left, Giuliano Amato needs no introduction. He has served in almost every distinguished role available in Italy and the European Union. He's been president of the Constitutional Court, president of the Competition Authority, and has twice served as prime minister. Angela Zhang, a frequent visitor to us here at NYU, is professor of law at the University of Southern California. She is a world-leading scholar of Chinese tech regulation, and she has taught the world over from Hong Kong, London, New York, and the West Coast. On the far end of our panel, Yanis Lianos, who is visiting us here as a visiting professor this semester. He is professor and chair of global competition law and public policy at the University College London. He is also currently a member of the Competition Appeal Tribunal in the UK and a past president of the Greek Competition Authority. And this group has been assembled to lead us through the broad and mysterious realm of competition policy. Now look, I've never been at a panel that didn't start by saying, as we know, this is an extraordinary time of upheaval and unprecedented change, right? That is the standard way to open any discussion about any topic of note. But my goodness me, if it's ever been true in antitrust, it is true today. After a couple decades of pretty robust, soothing, technocratic consensus on both sides of the Atlantic, if not more broadly throughout the world, the competition policy world is in new terrain indeed. So around the world, we're struggling still with our very first wave of tech competition and antitrust enforcement actions and living with the early days of digital regulation, most famously, but not only, with the Digital Markets Act in Europe, as well as other measures in jurisdictions throughout the world. AI, just to say it out loud before we get too far into the discussion, is reshaping business practices and regulatory expectations in ways that haven't even started to become clear. At least in the US, the post-neoliberal critique of the antitrust consensus is, with astonishing speed, gaining political ground on both the left and the right, and around the world. Secular trends towards closer economic integration, interjurisdictional cooperation, closer economic links with respect to trade and commerce, and political integration of all kinds are under profound assault, renegotiation, navigating new terrain indeed. So, the purpose of our conversation today is to have a spontaneous, open-minded, open-hearted discussion about some of these sharp questions, which makes my job very easy. We have a series of big picture questions in mind, many of which we hope to get to. For each of them, a couple of our conversationalists are going to lead us off with some framing reactions, but then after that, we're just going to have a free exchange and free reaction to one another. But we're going to start with what might be the biggest and most obvious question of all. So at a time of profound political upheaval around the world, how, if at all, is that shaping competition policy at 10,000 feet? So political upheaval of all kinds dominates the news pages. How is that affecting competition enforcement, not here in the United States, but in Europe and in China? And I want to start with Angela for a global perspective, and then we'll come to Giuliano.
Oh, wow. Okay. Hello, everyone. First of all, I would like to say how incredibly honored and grateful to the Household Program for inviting me to today's event. I have to admit that when I first received the invitation, I seriously debated for 24 hours because this is my teaching week and my kids' school week. So that means that I have to abandon both my students and my kids to come here. But I think NYU treated me very well when I was a global professor of law, and I think that I need to return this favor and coming here. Although when I said to Kevin just now, when I came up to the stage, like, as soon as I speak, you probably regret inviting me to come here in the first place. Now, going back to your question about how political upheaval has affected competition policy in China, I guess you ask, what hasn't, is there any place in Chinese competition law policy that is not affected by political upheaval? Because right? I mean, this is a communist regime ruled by the Chinese Communist Party, and the CCP has always seen law as an instrument of regulatory governance and a tool to organize a society and its economy, right? So from the very beginning, I studied Chinese competition policy, which is when I was a JSC student at University of Chicago more than 20 years ago. I have always seen it as very political. But that perspective was kind of an outlier, because if you look at the whole antitrust community, the whole academia, they live in a way for a long time. I think it's a very utopian world, seeing antitrust as purely grounded in economics, right, in theories. Why I was an outlier, seeing from the very beginning, this is a very political area of law. So instead of starting any economic underpinning of antitrust law, my scholarship has always focused on the bureaucratic politics of China's antitrust policy, how industrial policy has driven China's enforcement agenda, or even how geopolitics has changed China's enforcement trajectory, right? I mean, how China has weaponized its antitrust law to counter U.S., sanctions and restrictions. So much so that I even wrote a book. My first book is called Chinese Antitrust Exceptionalism, okay? Now, reflecting upon what has happened, to our world in the past 7 or 8 years, I feel like Chinese antitrust is no longer exceptional anymore because all around the world, people start to see antitrust as another political tool to discipline the big tech, to change the way, politics is run. So, right? I mean, fundamentally, might affect democracy. So, but going back to China, right? This is a tool to discipline its firms, and it's a really useful tool, right? I mean, a few years ago, when you think about all the headlines running in your newspapers, all about China's crackdown on this big tech, and the sharpest tool that they have is China's antitrust law, because this is an area of law that affords the Chinese government tremendous discretion, and they can impose huge fines on this company. They can even threaten to break them up, like do whatever they want with these companies. So the grabbing hand was featured very prominently, in all this even academic discourse or media coverage about how China uses antitrust law, and that crackdown was very heavy-handed, right? You see companies like Alibaba, Tencent, these Chinese big tech giants, they all succumbed to this pressure from the Chinese antitrust authority. Alibaba received $1.5 billion of fine, and they thank the regulators and move on with their life, right? But despite all this heavy-handed intervention, you ask, has it really fundamentally changed China's competition landscape? Has it really benefited the consumers? The question is far from certain, right? To this day, Alibaba is still the dominant firm. If anything, it's become even more dominant in the AI era with all the power and the compute that it has, right? And maybe perhaps let me stop here before I give the floor to other speakers. We have more to talk about, but certainly this is a very, very sharp tool the Chinese have used to discipline its companies.
What a wonderful observation. Maybe this moment is not quite as exceptional in every jurisdiction. Maybe the world's just catching up to China. Giuliano, let me come to you. What's the perspective from Europe? Is political upheaval and the winds of political change blowing into competition policy?
No, I wouldn't say so. There is a political upheaval around. Does it work? Yes. But to make it short, the populist wing that is part of this upheaval is not against antitrust. It's substantially where the antitrust got born in this country. It was a populist movement that led to the Sherman Act, substantially protecting the small against the big one. Antitrust. This is the original sense of the thing. Now, this has remained now. Those who are against are not the populist supporters of the small ones, are the big ones, are the ones who like their liberty, their freedom to be unchecked. And that's why some of them say that democracy and freedom are incompatible with each other, which takes courage to be said, I must say. Anyhow, nowadays, that kind of upheaval that asks for fewer regulations is affecting Europe, and I will go to that afterward, but not antitrust. The traditional opposition of antitrust to the abuses of power finds nowadays not only the traditional tools of antitrust, but also new tools to be somehow limited. Does Microsoft tie its teams to the software services? There is an investigation and there is a decision. Does Google refuse interoperability in its platforms to other providers? There is something new here, very interesting, that is a sort of link between antitrust and regulation. We have this Digital Market Act, as you know, part of which, Article 6, for those who like the legal quotations, that gives the Commission the power to establish a very bizarre thing, a regulatory dialogue with companies, which means I don't open an investigation. I want to help you in doing what you are supposed to do. Inside the Digital Market Act, there are companies not necessarily dominant, but in a heavy position, let me say so, in the market, that are defined gatekeepers. They concur to defending the order that we want to establish in the digital market. And the order is a competitive order. It's a competitive order. So, just a couple of months ago, the Commission opened this dialogue with Google to decide together how best Google could open to other providers in view of interoperability. Is this a joke? No, it's not a joke, it's serious, and Google will do it. Now, the extraordinary impact of this thing is that when these companies that sometimes feel victimized by Europe, is this the verb that you hear around?
It is.
Victimized. they decide that it's better to do what Europe suggests globally. Globally. This is the case I was referring to of the latest tying by Microsoft, which is a sort of ancient subscriber to tying. They did it with Media Player, they did it with Explorer, and every time they found a decision with Explorer, also in this country, if I remember correctly. Now, there was a long discussion between the Commission and Microsoft. The final decision was not a final decision, was a decision with commitments, that is before the final. The European equivalent of the consensus decree somehow. And they decided to split, and the decision by Microsoft has been applied globally, also in this country.
So it's a California effect or a Brussels effect, if you like, of sort of indirect regulatory effects.
Exactly. Let me stop here because I want to deal with something else later on. We are so, let's say, up to what is happening in this area that one of the latest routes for future antitrust action is collusive pricing by algorithms, which is a wonderful case because if you remember, this matter began in this country, if I remember correctly, in California, US versus Tompkins, 2000, you should know it because you're there. I don't remember exactly which district court, but it was in California and in 2015. In that case, the two companies had decided to use the same algorithm to fix prices. Now, this was easy.
Just as if they'd asked the same third party.
Perfectioning AI, nowadays, two different algorithms of two different systems of AI can contact each other and conclude for collusive pricing. This is quite a problem for us, but we are working on it. Let me stop here.
So this is a great way to set the table for our discussion. In response to the question, is this political upheaval blowing into competition policy? I'm hearing the answer no, because in China, it was never otherwise. And because in Europe, the nature of the political upheaval has been disconnected from any efforts at competition policy reform. Let me just throw it open and see if Yanis wants to come in and react.
Yes, I would like to react. Let me just say that I'm just sharing my own personal views, not those of the tribunal. I have to say that, otherwise we'll be in trouble back in London. So I will actually a little bit differ in that statement, in the sense that I think political content of antitrust was always there. There's a famous article by Bob Pitofsky back in 1979 about the political content of antitrust. And we're living this type of cycles anyway, all right? So as President Amado was saying before, the grandeur movement, the populist movement led to the Sherman Act. Then we had, with the Chicago libertarianism, a phase of no enforcement. So there is this kind of political aspect, internal politics aspect that I think very much influences antitrust enforcement. But when we talk about politics, we shouldn't only focus on the internal politics. It's also the geopolitics, I think, which are important. And there, I think, and obviously Angela is much more versed in Chinese law than I am, but I think that with my work at the BRICS a few years ago, I had the feeling up to 2018-19 that competition law wasn't really a priority. Of course, we have the Anti-Monopoly Act in 2007. I actually felt that it was becoming more of an issue, particularly the digital platforms. In 2019-20, we had basically the publication of some draft guidelines, but then I think suddenly, in the last couple of years, a little bit the mood has changed. So these draft guidelines have been always draft, not really implemented as such. Then, we have all these discussions in Europe now about growth, innovation as being extremely important in order to catch up the technological race with the US and China. And that has led some people, not necessarily because of course, libertarianism there might somehow find a synergy with this geopolitical argument. But basically the idea being that, we shouldn't enforce that much our merger control because we need scale in Europe, we need to develop a little bit broader. So I think the political aspect of antitrust has always been there. And in a way, also, if you think about the history of antitrust law diffusion, I mean, when, the US started pushing Japan in the 1980s to implement antitrust, it was because they were feeling that Japan was not really implementing antitrust. You had the Keiretsu, the Zaibatsu that were actually expanding their power and developing, while in the US there was a period before the 80s that was really active in force of antitrust. So the idea was, we don't have industrial policy at the national level, as the Japanese have with MIFI. Let's try to push the Japanese to apply antitrust law more aggressively, right? And so the idea of politics being always present, both in from the internal politics perspective, but also from a geopolitical perspective.
Gosh, that's a sort of a measure of the tangle and complexity at the current moment. I just want to touch back to something Angela said. So, and to ask a question that may be naive and underinformed. So your observation was, gosh, there's nothing exceptional in China about political upheaval or political dynamics driving competition policy. Is there anything sort of unusual about that effect right now, or is it just sort of business as usual in China, regardless of the upheaval we see in the United States, in Europe, and elsewhere?
Well, great question, right? Let me clarify my points better. So there's a saying, almost like a mantra among lawyers in China, that big cases are decided by politics. Medium cases are decided by relations. Small cases are decided by law in China. Okay?
That's great.
So
and I'm not sure it's confined to China.
Okay. So it's not everything is political, but things that matter. Okay? The big cases that matter are all very political. Okay? Now, I talk about China's grabbing hand, but when you flip this hand, it is a helping hand. It's still the same hand by the Chinese Communist Party, okay? And I talk about China's tech crackdown on its national champions a few years ago. Very brutal, relentless crackdown for 18 months. But I should also emphasize that before that, it was a really, really lax regulatory environment. In other words, the government was extending a helping hand, providing a very business-friendly environment for its own tech firms to succeed, to prosper, and to flourish. And that's why China have one of the largest, I would say the second largest tech ecosystem right behind the United States, and why China is now almost neck to neck with the United States in terms of the AI competition, right? Without this helping hand, you will not see, the tech sector in China today, which I think why the Europeans are getting envious of what China is doing, right? With all this tight regulation that you're talking about. But then why this unusual crackdown on these tech firms? Because the Chinese government thinks that this is not working. We want common prosperity. That doesn't mean communism, but we don't like the fact that these big tech companies have aggregated so much wealth in a number of small number of elites. People like Jack Ma, right? Who was, at the end of 2020, when his fintech giant Ant Group was going on IPO, he was on path to become the richest man in China. Ant Group is going to be the largest fintech giant. And by the way, he personally controlled 50% of that company. So he's going to be kind of like Elon Musk in China. The Chinese Communist Party just can't sleep well at night thinking about, a private individual control 50% of Chinese financial system. Just that plain simple. But do they have a legitimate reasons to go after this company, to crack down on these firms? Perfectly good reasons, right? For a firm that has such an opaque corporate governance structure controlled by one single person can potentially pose a systematic risk to the financial system because at that time, the firm was valued at $320 billion US, bigger than JP Morgan, which is the biggest bank in the United States at that time. If you put yourself into the shoes of a regulator sitting in PBOs, the People's Bank of China, you will be worried about systematic risk. So there are perfectly legitimate reasons to go after these companies, to crack down on these things, to address income inequality, with all these things. Similar thing we're talking about in a democratic setting as well. But there's definitely a political dimension to that, right? So antitrust law doesn't live in a vacuum. And antitrust just happened to be one of the sharpest tools the government have identified that they can use to discipline these companies, and an incredibly useful tool. However, the government's walking on a tightrope. That's why I wrote my second book called High Wire. The leadership is walking on high wire because as soon as you start this intense crackdown, you spook investors. International investors flee the Chinese market. They think the Chinese law is unpredictable, very arbitrary. China is uninvestable. That's why they eventually ease the crackdown. Maybe let me stop here. Otherwise, Daniel is going to, penalize me.
There are no penalties today, and we're not attached particularly to our outline. But one thing that is buzzing in my head as I listen to all three of you, and in fact a theme of your scholarship in different ways, is what we might think of is the content of antitrust separate and apart from traditional welfarist, technocratic, microeconomic-driven analysis in a way that we can sometimes think of our antitrust system in the United States as being or having been. So Juliana, you talked a little bit about democracy and freedom as a theme of digital regulation. Yanis, you mentioned the political content of antitrust as an irreducible piece of the puzzle. And of course, Angela, you're focusing on that as a dominant theme in China. But I want to pull that out into the light and take a closer look at it. Because there are a lot of calls in the United States and in other jurisdictions to get rid of that technocratic, welfarist, economics-driven, blackboard economics-driven style of doing competition policy. And I just love your impression of what that alternative or set of alternatives might really look like. Is a post-welfarist or a post-neoliberal antitrust competition policy desirable? Is it even normal in some jurisdictions like China? Is it something that we can have, should want? I want to start with Yanis, and then we'll perhaps go down.
Well, thank you, Dan. That's a very important question. And I think with the 2008 crisis, we saw the starting of a contestation of the neoclassical price theory model we have been applying for almost 45, 50 years. And these contestations took different forms in Europe and in the US. I think in the US, because of these, the contestation did not come from within. I mean, Lina Khan is obviously a competition lawyer as well as Tim Wu, but their language, in a way, was not that of the classic antitrust law language. It was a constitutional law language. It was a rights-based language. Was very much trying to connect antitrust with the progressive populist movement of Brandeis, a specific interpretation of Brandeis called New Brandeis. Some people would say that's not exactly what Brandeis thought, but anyway, I think the narrative was important. And therefore, the focus was there on democracy, economic democracy, the links to democracy, but also not necessarily only focus on antitrust, but also suggesting eventually regulation as a possibility, particularly for firms that have a size or scale that, of course, it's efficient, right? So there was a public utilities type of paradigm coming in. In Europe, I would say the contestation came from within, because you have a number of authors, competition law authors, that some of them have been going back to the the vision of the ordoliberals. Some others have been focusing on integrating, to a certain extent, capabilities approaches like Amartya Sen. Some others, like myself, have been basically focusing on a new form of technocracy for antitrust, not that based on a classical price theory, but based on complexity science, based on political economy, on network analysis, because that will provide us the wider picture we need to understand the impacts and effects of our policies, right? And I think it's not really that, I think the institutional differences between Europe and the US explain these different approaches. In the US, antitrust is mostly enforced by the courts, right? The courts are actually much more, and the judges, being lawyers, they respond to, and being generalists as well, because there are no specialized courts as the one we have in London, for instance, or in other jurisdictions. So the judges are basically, they can respond better to this language of rights. That's why I think I might expect, and I'm a little bit more optimistic about the success of the new Brandeis movement in the courts, even if we have, because of some reasons which we can discuss more thoroughly, some eventually bad consequences so far. I mean, for some cases, some other cases have been quite successful. I think because of this language that I think might eventually attract the judge's attention. In Europe, enforcement is done by competition authorities, and particularly by the Commission, which is not a competition authority. The Commission is a government, right? Because any decision of the Commission, even in the competition field, is taken by the College of Commissioners. And surely the competition commissioner's word is always more important. But we have seen cases like, for instance, the Google shopping case, where the competition commissioner Munya at the time did not succeed in convincing the College of Commissioners back in 2014 about the commitments of Google, and then we moved to an infringement decision. So I think that's quite important to have in mind. And the other thing I think is important to understand, so it's not like the welfarist approach of the classical theory. It's certainly an approach that looks to polycentric approach, as I call in my work, that actually very much is inspired by the concepts of polyarchy and a number of methodological and conceptual and operational tools that we can actually use to assess better power relations. And particularly nowadays where power is not exercised in separate fields, economics and politics, and these are not completely separate fields. Power can be leveraged from one field to the other. Economic power can be leveraged to achieve and influence political decision-making, or cultural, basically, narratives and cultural policies. So I think it's extremely important to have this idea of power, and different metrics of power that one would dispose. And finally, I wanted to say that if you think about, we need also to integrate the geoeconomic perspective. Why I'm saying that, and I'm not going to comment critically on this, I'm just mentioning as a fact. Very recently, the British Secretary for Science, Peter Kyle, made a comment concerning big tech. I noted it down because I wanted to make sure that at Justice, he said, UK must act, I quote, with a sense of humility when dealing with big tech companies, because we need to use statecraft rather than regulation in a certain way, and these are like nation states, right? I'm not commenting, I'm just mentioning this, right? So, which means that we have, and there's been recent work about the corporate autonomy of these big tech companies, that either these can be instrumentalized by the specific states in which these companies have more dependencies, or we can see these companies eventually being able to develop independent policies, and we can discuss about the example of even Starlink in Ukraine, and when actually this can be used or not, right? Which are not necessarily decisions made by the specific state or states which this company is based. So that is something that I think needs to be taken into account in international relations, and more generally the way we think about state power. And obviously that is an even further argument in the polycentric tradition that I put forward, to take into account this political power and eventually use ways to limit the negative consequences of that. And we can basically discuss later about some proposals on this.
That's fascinating. That's almost a tale of the coming of age of the competition law framework, where it sort of ascends or transcends the welfarist paradigm and starts to grapple with the kind of complexities you're talking about. The idea of antitrust as statecraft is going to live in my brain for the next several weeks. Angela, as somebody who focuses on, among other things, a jurisdiction where competition policy is perhaps not primarily in this welfarist tradition. How do you think about the rise and possibility of post-welfarist antitrust? Are you as positive as Yanis is?
Well, I mean, I just talked about the Common Prosperity initiative the Chinese government introduced during the most intense period of the tech crackdown, particularly in 2021, right, which aims to reduce income inequality, enlarge the middle class in China, address regional inequality, right, and eventually to improve productivity in China. This is like, motherhood and apple pie. Who doesn't want that, right? I mean, the Chinese government and then use antitrust as a tool to try to empower these various platform participants, be it smaller merchants, delivery workers, or you and me as a consumers, trying to empower these smaller players to better negotiate and bargain with the platform, right? I mean, so antitrust trying to bring back some balance to empower them. And these are well-intentioned, right? However, what has our Common Prosperity Initiative has led us after you see, these movements for so many years? It's like we worry about common poverty right now, right? I mean, because when you take a very heavy-handed approach, which is no longer very technocratically grounded, right? I mean, it's not, doesn't give a lot of actually give a lot of uncertainty to investors. They think this is very arbitrary. They're worried about uncertainty. They are worried about the unpredictability of the Chinese law. They're worried about the arbitrariness of the Chinese law. They don't like this investment environment. They flee the Chinese market, right? I mean, that's why this very pessimistic sentiments about China's tech in the past couple of years, that seeing this is a market that is uninvestable. Even today, investors started to come back, in the past couple of years back to China, because seeing what happened in the United States, the grass now seems to be greener on the other side, right? I mean, it seems the Chinese market is calmer, more stable. The policy is less volatile than, here. So anyway, so going back to the common prosperity and the worry about common poverty, right? I mean, so I'm personally, more supportive of a policy that, give more certainty, right? Give more predictability to the regime. And then, those technocratic analysis actually is the solid foundation for that.
Juliana, I can't resist bringing you in here. You have thought for many years and written about the relationship between antitrust and competition policy and power. And I don't often get to sit on antitrust panels with people who have been the prime minister of a jurisdiction or sat on a constitutional court. So let me ask you, from your combination of perspectives, do you hear calls in Europe to liberate competition policy from technical economics or from technocrats or even from bureaucrats, and to embrace more direct concerns about political power, cultural power? And if so, do you think that game is a wise one for antitrust to play, or antitrust should stay in its economic focused lane?
Well, I tell you, for Europe, the Amazon paradox was not such a revolutionary kind of thing. You needed a previous intense self-restraint of antitrust to consider the Amazon paradox the beginning of a new era. This was not the case for Europe. Europe had never been so restrained as the antitrust paradox had made the US antitrust. I still remember, you perhaps remember the case when there was the merger between General Electric and Honeywell that had the green light here and was prohibited by Mario Monti at the time, and the entire commission, as you said, in Europe in 2001. I still remember that the main argument here was But there is a reduction of prices immediately after the merger. And that our reaction was, this doesn't mean anything. This is an immediate effect that has nothing to do with the structural modification that will allow the new company in the future to act independently of others. And the American reaction was, I remember, we are much more humble than you in assessing the future.
Charles James gave a very critical speech, right? The U.S. was openly critical of the Europeans' application of its own laws.
So, I mean, there was this difference. Afterward, it was accepted also here that our decision was good. Anyhow, it took time. But the fact of the matter is that immediately after 2008, as you rightly said, Ioannis, there was, plus Lina Khan, putting the two things together, there was this idea that there are so many inequalities that we have to do something more, and this something more has to be done by antitrust. This was, and articles were written, debates, etc. How much more could we do? Now, of course, looking at the matter from the US angle, much more could be done. Mostly with mergers, because it was demonstrated at the time that the self-restraint vis-a-vis merger had allowed concentrations of powers and profits that had contributed enormously to inequalities. But can we really rely on antitrust to reduce inequalities in our society?
I was going to say, like, I recognize that there's something of a consensus in most circles that large number of unchallenged transactions have really fueled economic inequality. I'm kind of skeptical of that claim. Do you think it's right?
I mean, I read figures that somehow demonstrated that there were a certain amount of extra profits that quite likely would have not been existed without these mergers. But can you charge on these the existing inequalities in our societies? It's beyond the scope. It's beyond common sense. It's beyond what antitrust can do. And so in the happy atmosphere of this antitrust community, so happy to be considered crucial for the future of our societies, I wrote a couple of articles in which I said, take it easy, cool it off. Cool it off, because for a very simple and essential reason for the legal community, because we have received from the law a goal, but we can pursue that goal by using the means that the law has given us. We cannot use whatever means for the sake of the goal. This is against the rule of law, and we should abide the rule of law, which substantially means if we rediscover exploitative abuse that was somehow abandoned, using only exclusionary abuse. Exclusionary is the abuse that has the competitor on the other side. Exploitative has the consumer on the other side. So I can accept but up to a limit. Let me remind you of a famous German case, the Facebook case of 2019, in which the Bundeskartellamt, the antitrust authority of Germany, substantially dealt with the violation of the Digital Act as if it were a violation of the antitrust German regulation. The decision was challenged. There were repeated opposite views. Eventually, their federal constitutional court decided that it could be dealt with as an exploitative abuse. I remained quite skeptical on this, quite skeptical. If there is a regulation that is violated, it's up to the courts competent on the matter to decide. I cannot grab this thing. I can't go beyond what I'm supposed to do. Antitrust is very powerful, has got means to pursue the goal, and is very much respected in the use of these means. You see, even now, Google, Microsoft, etc., accept the decisions of our commission and of our court, but we have to remain inside the area of our toolbox, not trying to gain new tools that are not appropriate, and that we perhaps, a final example, when I was heading my authority in Italy, I was very wary on going on the excessive pricing which the treaty provides for, because excessive pricing seemed to me something that requires other competencies, that requires other authorities, not me anyhow. I used my time.
I want to offer Angela and Yanis the opportunity to jump in. Yanis, I see you have a thought already.
Sorry, so I just wanted to say, I don't think anyone, at least when I was talking about polycentric competition law, is putting forward the idea that competition law should become the law of everything, if I can use the expression of Frank Issenberg. And I think the political economy and the law of each jurisdiction will play a role. I think in Europe we do have in the treaty horizontal integration clauses, which are imposing to the Commission as well as to other institutions to take into account a number of goals and objectives. For instance, in terms of protection of employment, environment, etc. I think it is not that we are, in case the competition authority is looking to restrictions of competition that affect privacy, sustainability as a parameter of competition, right? We're not talking about situations where there's no relation to competition law. I would think that it would be political not to enforce competition law, rather than political to enforce competition law, because it is in the text of the treaty, and we need to enforce the text of the treaty. That said, in terms of the inequality dimension, I fully agree. Competition law cannot be the mega tool for equality. But I have to say that because of these discussions, we have been able, not only in Europe, but actually primarily in the US, to start focusing on things like labor restrictions to competition that were not absolutely part of the picture a few years ago, focusing on monopsony power that has also not been at the focus of competition a few years ago. So I think this discussion has, and these are technical, technocratically, it's not political. You can actually have a technocratic assessment of labor restrictions to competition and inequality of bargaining power. So I think these discussions have led to a technocratic development of some democratic dimension of competition that focuses on this. And that's the argument of polycentric competition. Let's actually use not just classical price theory, which could be very helpful in some circumstances, but innovation economics, network analysis, agent-based modeling, for instance, in order to help us identify these type of restrictions to competition, and not just to consumers, but also to workers, as well as eventually, affecting restrictions to innovation that is basically protecting investors, right? So in a way, I think we have to open up a little bit, or sustainability, which is about citizens, or future generation of citizens. So I think this is a kind of opening up our box in order to get not just a consumer aspect, but also all the other dimensions that we have in now games of life. We are a consumer, we are the worker at the same time, we're a citizen at the same time. Why should we only focus on our consumer dimension when we apply competition law. That's basically the polycentric approach.
Let me invite Angela to react, recognizing that the jurisdiction on which you focus is, if not using antitrust as a theory of everything, is at least much closer to that than the jurisdictions we're talking about.
Right. I actually want to react more broadly to today's discussion because I spent a lot of time both in China and the US and also in Europe. So I see China both as an insider and an outsider. And you probably have heard about a book called Breakneck, which was a New York Times bestseller on the US-China competition. And it said the United States is a loyalist society that constantly debating, arguing, and never get anything done. And China is an engineering state that just keep build, and then they have this state capacity. I want to flip that argument. I actually see the United States is actually governed by tech, whereas China is governed by law. The reason why I say that relates to today's theme. When you see, China can afford to use its antitrust law with a split second and can discipline its big tech and, trying to use antitrust law to achieve common prosperity. Redistribute wealth. But look at the United States. Despite all the intense, scrutiny, all the litigations, all the investigations, and all the hype you have in the congressional hearing, all these things, what have we really moved the needle a little bit? Not really, right? So let's lower expectation of what antitrust can really, change the dynamic in this society, because fundamentally, if you look at American society today, right? Why I said it's governed by tech. The tech has elected our current president, and I don't know who knows, maybe the next president. Tech, like the Magnificent Seven account for over 1/3 of the S&P 500 right now. Anything that happened to OpenAI, we will see our AI bubble burst. It control our finance. It control our jobs. I will be out of jobs. In a few years, the AI is going to replace me. And what else it doesn't control in our society? We ask, right? That's why I think that fundamentally it was the power imbalance in these societies that truly matter. Who has the upper hand? In China, clearly it's the government. Okay, whether we use antitrust law or data privacy or whatsoever, right? And that's why I said China is governed by law. In this country, it was the company that has the upper hand. Okay, let me stop here.
I have not heard that perspective pushed before, and that is completely delightful. So we've been talking at the level of principle primarily, but I want to zoom in now both to Europe and China in a little bit more of a concrete way. And I want to start with Europe because the European regulators, competition enforcers, scholars even, were talking about increased aggression of tech competition policy and competition enforcement long before that was even on the mainstream radar in the United States. And I'm sort of curious about how that's going. So there was a period where the European Union was clearly sort of out in front, in some sense, bringing antitrust cases against many of the big tech companies. We've heard a couple mentioned, the actions against Google Shopping, a German case against Facebook that's kind of complicated in a couple ways. Lots of regulatory efforts, the Digital Markets Act, Digital Service Act, GDPR, AI Act. But I sense a slight change in the music in recent years. Political situations a bit more complicated, economic situations more complicated. The Draghi report has gathered a lot of attention with a call, among other things, for some regulatory caution. So my big picture question, and I want to start with Giuliano and then go to Yanis, is how's the competition policy conversation going in Europe? Is there more caution and hesitation than there was 5 or 10 years ago? Is it right to think of the situation as one where maybe a decade ago there was tremendous enthusiasm and unity of perspective around the need to regulate and intervene pretty robustly through legislation and enforcement action, and that has slowed or complicated now? Or do I have it wrong?
No, I mean, if you connect competition policy with these matters, perhaps you are not completely right. In the sense that, as I said, competition policy is a little bit at least immune or not so touched as other regulatory forms where there is a deep crisis in Europe nowadays due to two different trends. On the one side, a domestic European trend against the considered unilateral regulations to face climate change, which is a populist European reaction against stopping the traditional engines in 2035, not using certain products in agriculture, having a very strict, as we name it, ESG, environment, sustainability, governance, regulations for companies, etc., on the one side. On the other side, the American companies are saying, you're victimizing us. There is an over-regulation in Europe. We can't live with this. Now, these two forces together are affecting one of the pillars of Europe, that is the regulatory attitude. I remember an article years ago in the New York Times, perhaps by Friedman, one of their editorialists, the title of which was Europe Save Us, asking for European regulations that the Americans were not ready to adopt, etc. Now the mood is quite different. Now, let me say, something has to be done. As it is, the European regulatory world is not defendable. The attitude to over-regulate does exist. It does exist. I'm a regulator by instinct, I must say, so I have nothing against them. I understand I belong to the same race. But I have to tell you something. I was very much in favor of the regulation of April last year on artificial intelligence. In my view, it was essential and good, the 4 risks, the different rules. When eventually it was adopted, I put myself before the text. I started with an article. I couldn't reach the end of the article. I got mad before the end, paragraph after paragraph. At the 3rd paragraph, I did not understand anymore what I was reading. And I said, my God, how can I defend this thing now? So, too much is too much. And really, this was exemplary of a way of regulation. So I understand that some American interlocutors apparently fight against over-regulation, but their objective is regulation as such. But we give them a good reason for their battle. And first of all, let us get rid of over-regulation. The Commission now is working on this under the old heading, Better for a Better Regulation. A process of simplification has started off, and it is essential. Also, on the other side, something has to be done. The regulation related to climate change. I give you an example. It was adopted after the so-called Green Deal of 2019, a rule the name of which the acronym is DNSH, do not significant harm, which is such a unilateral rule that implies the following. There are financial incentives for those who adopt productive changes that reduce their emissions, okay, quite obviously. Well, but if you pass from, let's say, an energy source that has 10 of emissions to another one that has 5 of emissions, you are not entitled to incentives because you are still doing significant harm.
Even though it's an
So
improvement.
either you go from 10 to 0 or you are not eligible. So, I mean, obviously there was a reaction to such a rule. Now the rule has remained, but it is applied in terms of balancing. Now, learning and balancing is an essential instrument of government, is something that Europe is now learning.
There's some moderation
Yeah,
coming in.
But here, there are things that have to be done.
Yanis, before we take the zoom lens of our attention to China and to interjurisdictional rivalry with the United States, let me just invite you to follow on the back of those two diagnoses of Europe.
What President Amaro said, I mean, you might need AI to understand the AI Act eventually. But what I wanted to say is the following. So I think we do have this discussion about overregulation. However, I do not think this discussion concerns or targets antitrust. First, actually, in the area of competition law, particularly the work that has been done with regards to sustainability, which was basically the first episode of integrating some form of industrial policy concerns in competition law enforcement, in the way that we will not necessarily enforce competition law to initiatives, cooperation agreements between companies that will try to move forward sustainability, so environmental sustainability objectives, and you have that in the new horizontal cooperation guidelines. The Commission last summer, they started adopting opinions with regards to specific initiatives that, although they might have raised competition concerns, they did not actually enforce. In Greece, actually, even changed the law in a way that we can adopt no action enforcement letters in case, and a sustainability sandbox to enable basic competition authorities to promote sustainability for the different reasons, because of the small size of the firms, and they need to cooperate. So there is basically competition, this understanding that yes, in some cases you need to not necessarily aggressively apply competition law and do some balancing. And secondly, it depends. I mean, you have a lot of people raising issues about, aggressive enforcement might lead to reduce incentives to invest and eventually affect innovation, which in some cases it might be correct, but in some other cases, not enforcing competition law, for instance, concerning killer acquisitions, might eventually also lead to a restriction of innovation. And obviously, you need to do a case-by-case analysis. But I wanted to say, however, about Draghi. I mean, I think many people, they use the Draghi report as a way to say, this is the competition law and enforcement, Draghi is actually against that. I think that Draghi is very careful to distinguish between symmetric regulations and asymmetric regulations. Symmetric regulations are those that apply to firms even if they have power or not. And these could be AI Act, could be eventually the GDPR, right? So he raises concerns about that. Although I think for the GDPR, I think it clearly says, well, maybe from an economic perspective, it doesn't make sense. There is a cost, and if as a society and democratically we think that this is a cost to pay, I can live with that, right? And I like this type of approach in the sense that the costs are visible, and then the societal choices about moving forward. But I don't think Draghi is basically saying anything somehow in favor of a more regressive type of competition law enforcement. Many people have actually raised the arguments that he makes about innovation defense, but actually this is done only, he mentions that only for non-tradable sectors, right? And he particularly he actually, confines it to very specific types of circumstances. He's actually in favor of the new competition tool, market investigation, which is basically much broader than what we actually have in Europe. He raises some issues with regards to telecom mergers. Some people have criticized that because the mergers actually that happened in the telecom sector and that the Commission might have somehow, or member states might have prohibited, these were not mergers between companies across Europe. It was basically within a specific jurisdiction, right? So they might have led to an increase of power. So I think it's not that Draghi is basically pushing for a no competition enforcement agenda. Actually, pretty much the opposite. And I think we need to distinguish between symmetric regulation and symmetric regulation. Obviously, I will be in favor of simplification and an effort of reducing regulatory burdens with regard to symmetric regulation.
So you touch on a lot there. One of the themes in sort of that sweeping perspective is the occasional role of other policies as a ground either for abstinence from competition enforcement or for affirmatively taking it, including environmental policy, social policy, or industrial policy. And Angela, I want to come to you and bring you in and ask whether you see concerns of those kinds, perhaps particularly industrial policy, and maybe above all competitive industrial policy between the US and China, as driving the subject matter of your scholarship. Do you see those forces influencing regulatory behavior in China or the interactions with the US, or has that now settled down from the high points of previous years?
Yeah, thank you for giving me opportunity to shamelessly promote my own scholarship. Does geopolitics matters? Basically, for antitrust, and it matters hugely, right? I mean, whether in the United States, and you're familiar with the Google litigation, right? I mean, the China card was played very prominently in that litigation. Google in its submission says, if you're going to break us up, right? I mean, DOJ, if you're going to break us up, how can we compete with China? We are, we represent the future competitiveness of the US AI, technology. Right? And that's not an overstatement. I mean, Google is indeed probably the most important AI company in the United States, right? And you also see this China card was played, in the current administration, right? I mean, with the AI action plan calling for deregulation, right? I mean, and then also all the executive order trying to bring all the states together, right? I mean, let's not have 50 patchwork of regulation of AI. We should be, have just one coherent approach, and we should take a very lax stand in regulating this technology so that we cannot let China to get ahead of us, right? Does it make sense, right? I mean, with generative AI, I'm a little bit skeptical. You see smaller companies like DeepSeek can emerge and do amazing things with comparable capability. But I think there is some truth to that when it comes to physical artificial intelligence. If things like autonomous driving, drones, and the robotics, humanoid robot, all these things, they require tremendous resources. And you just cannot do it if you're a smaller firm. Right? It's unrealistic to expect just a tiny lab can afford doing these huge tasks, because they require extensive experimentation, deployment, testing. You need a lot of resources, and not to say investing in the technology itself. Because if you look at how the Chinese compete, the Chinese have tremendous state capacity, unlike the United States. You pull in 10 different directions. China only go one direction. So they can marshal all the resources, the whole of society approach, to just pivot for growth and development, right? If they want to develop robotaxi, they can do it. In a couple of years, you see 20 cities have rolled out robotaxi. So far, how many cities in the United States have rolled out robotaxi for commercial deployment? Not even in New York. There are 8 cars in New York, but they are not for commercial deployment, and there's a safety driver behind the wheel, because the New York law prohibits fully autonomous car on the street. The state legislator needs to get together and change the law before we can allow that to happen, right? But the Chinese can do that in a split second because of their state capacity. They can coordinate things very quickly. Whereas here, it's a democratic setting, right? You need to listen to different opinions. So it's harder to get things done. So when it comes to that, right, I mean, physical AI, I see China and the US, they both have such strengths and weaknesses, and China is actually, in some way, have very strong competitive advantage because they can coordinate. So as a result, the United States, because of the lack of state capacity, it needs to rely very heavily on its big tech firms like Google, Tesla, NVIDIA, these firms that bet very heavily on the future of physical AI. So if you're going to use antitrust law to break them up, undermine the competitiveness, open up the market, you are in effect undermining the competitiveness of the US, vis-a-vis China. And that's a serious dilemma I think the United States are confronted with, unfortunately. So we can't have both democracy and national competitiveness at the same time. That's the paradox we're living in.
Gosh, that sounds like a new forthcoming book with a paradox title, The Competitiveness Paradox. So I know we're almost out of time, and I'd love to be able to take one question from the floor, but I just want to do a very quick lightning round with our three panelists, if they're willing, just to ask them to throw their minds 10 years into the future. As scholars and people who work on policy, it's helpful to know about the past and it's important to work on the present, but ultimately part of the job is helping to shape the future. What, if anything, do you think will be different when the four of us are gathered for the next, Hauser anniversary celebration and we're gathered again to talk about competition policy? What will be different in an important way from the way it is today? Giuliano, if you're willing, I'd love to start with you. 10 years' time, what's changed?
Well, the scenarios that we read now are terrible for the future.
For sure.
The most, let's say, accepted around is a word where you have, on the one side, failed states, on the other side, authoritarian states, democracies that are already falling down in 10 years won't be with us anymore. Failed states means something that I don't know whether you have experienced it, but it's really, you can't believe it that you are crossing a street and every 2 blocks an armed group stops you, and it's a different group from the one of 2 blocks before. And there are therefore different small authorities that are substitutes for an authority that does not exist, and therefore it's a mess. On the other side, authoritarian regimes. Antitrust remains in the hands of God, I suppose, at that point. I don't think it will be so. Perhaps because I'm too old to be pessimistic. At my age, you can't also be pessimistic. But there is something in my mind that a word made up of failed states and authoritarian states can't have a globalized economy necessarily, because each of these big and small authorities would create obstacles, hurdles, taxes, divisions, conflictual. Now, none of our economies can survive without the exchanges of globalizations nowadays. Perhaps decades ago, we could do it. But take the case of China. I don't enter in. But China, without globalization, would be a disastrous economy substantially. Even now, they depend more on exports than on internal consumption. But it's an example. I buy here and sell there. I need a component and I get it here and not there. I know that I can't produce everything on my own. So it's such strong, the pressure coming from the economy, that perhaps you can't believe it. I can't believe it as an antitrust. But the needs of contemporary economy might be the propellant that will push for the preservation of a system in which we can survive. Not all of the regimes will be democratic. There will be some failed states, but on the whole, the world system will be the system we have in mind. And this is, in this system, of course, antitrust will be an essential pillar, I'm sure.
That's the most beautiful vision I've heard of the international future for the better part of a decade. I wish I had recorded it so I could listen to it in my shower every morning when I start the day. Thank you. That's a wonderful beacon. We have, I think, 1 minute left on the clock, so let me ask for 30 seconds from Angela, looking 10 years into the future, and 30 seconds from Yanis as we close on this optimistic note so far.
I can't even predict whether Iran will initiate drone attack in California, hit my house tomorrow. So it's hard to predict what will happen 10 years from now, right? But if I am lucky enough to be invited 10 years later, I would think that we will have a new law other than beyond antitrust, because AI is going to disrupt everything in this society. If you look at the previous industrial revolution, each time it comes, it rewrites the social contract. And I believe that we will have a new legal innovation that will drastically rewrite the current social contract. So we don't need to count on antitrust. So next time, I will talk about something else.
That's awesome. Yanis, the last word also, hopefully in about 30 seconds, is with you.
More pessimistic about society, more optimistic about antitrust. And I explain myself. I think what we're seeing, particularly with agentic AI and the development of AI, is that it questions the existence of a market system, in the sense that if most of our buying and selling would be done through AI agents, and if actually AI infrastructure, infrastructural power is only for certain states, but not necessarily all of them will be able to develop that, and I will rely on somehow very few companies to provide this AI infrastructural power. I think this raises very interesting and important questions about, antitrust as economic statecraft, right? And how actually you can use, and you can eventually, if I use a term of Farrell Newman, weaponize interdependencies and eventually using regulation in order to achieve specific objectives and avoid this type of future emerging. So, for instance, having interoperability principles and design as a design of the digital economy, promote that at the national level with willing jurisdictions to hook in the nodal, basically, power that Europe has as a digital regulator right now, but might evolve in the future. These are types of approaches that will eventually ensure that we have competition law, not for markets now, but for controlling ecosystems, might have some role in the future. And we can talk about that in 10 years' time.
Well, I can't think of a better way to have spent 75 minutes than listening to the three of you. I hope you feel the same way. Please join me in thanking our panelists.